Secretary, please call the roll to establish the quorum.
Han?
Here.
Han here. Melendez? Here. Melendez here. Eggman? Here. Eggman here. Gonzalez? Grove? Here. Grove here. Hurtado? Leyva? Limon? Here. Limon here. Roth? Here. Roth here. Rubio? Weiner? Here. Weiner here.
Okay. Thank you. A quorum is established. So we're going to begin with what is now item number 1, AB 2223, with Assemblymember Wicks. Again, as I mentioned, public comment was already taken yesterday, so we will now just be returning to member questions and comments. I will just make note that again, we need to maintain decorum here in the committee, and so let's now open again AB 2223 for member questions or comment.
Has there been a motion to move the bill yet?
I have a comment.
Okay, I do not. Is there a motion? Okay, it's been moved by Sarah Eggman. All right, questions or comments? Senator Melendez.
Thank you, Mr. Chairman. Okay, so let's reconvene. This bill says that an inquest, an inquiry, an investigation into a death of an infant doesn't have to happen. So I'm trying to understand how we can make sure that nothing illegal took place with the death of a child if an inquiry doesn't take place, because there is a fine associated with conducting an investigation. So there is the threat of being sued. So it's going to be difficult to imagine a situation where these investigations are going to take place on a regular basis because there is the threat of being sued. So if there's the threat of being sued, if you just even look into the cause of death, not necessarily bring charges, but look into the cause of death, then less investigations will take place, which means there are going to be many cases where we have no idea why the baby died.
A medical doctor can prompt a coroner's investigation should they determine the need to do so.
Okay, but it says that if you do that, you can be sued for that. And so then we go back to what we talked about yesterday, which was the difficulty in determining if something happened to that baby in utero or after the baby was born, which can be difficult, to determine. I mean, there are cases where doctors have just said, we can't make a conclusive determination.
So coroners will continue to investigate alleged crimes. If a baby is born alive, that is now a person who has rights. And if something happens to that baby where they are harmed or injured or, God forsaken, murdered, the coroners will be able to investigate that. Law enforcement will be able to investigate this. That bill changes none of this.
Well, I understand what you're saying, in that the bill doesn't prohibit an investigation. It just says it's not required. But again, the concern is the threat of a lawsuit, which means we will likely have, do you have any concerns about that? That there may be, coroners who choose not to do the investigation for fear of being sued?
I do not have that concern.
You don't have that concern. So, okay, then moving on.
And I would also say, if the coroners had that concern, they would oppose the bill, and they're not.
So then let's move on to the section that talks about not using anything on the death certificate in bringing civil or criminal charges against either the mother or anyone who assisted her. So if you can't use the cause of death in a criminal matter, then how do we stop people who are not supposed to be performing abortions or who did so illegally? Because the bill does talk about criminal abortions. How do we stop them from operating if no charges can be brought against them, or the cause is not allowed to be used in a criminal matter.
If I may, Mr. Chair?
Yes, Chair.
We have legal counsel from both Planned Parenthood and ACLU here today as expert witnesses.
All right, if they wish to approach and provide an answer to Senator Melendez.
Good morning, Ruth Dawson with the ACLU of California Action. Thank you for having us today. So this bill does not change the threshold for when a coroner can craft a fetal death certificate. Health and Safety Code 103005 in the bill says that the certificate cannot be used to prosecute someone who's immune from liability in this particular section, 123467. So gathering information about the causes of pregnancy loss is an important component of addressing longstanding crisis in maternal and infant outcomes for Black, Indigenous, and other people of color. And this bill does not change the requirement of public health reporting of fetal deaths under the pertinent health and safety code, and thus doesn't interfere with the collection of that data.
All right, thank you.
Okay, thank you for clarifying that. However, that brings us back to where it says in the bill that you can gather the information, but you can't use that for any sort of criminal charges. So it doesn't really do you any good if you can determine that something nefarious took place if you're not allowed to actually use that, right?
Well, do you want to address that?
Sure. So also to take a step back, the question you asked earlier about criminal abortion, that is actually an outdated term, which is part of why this bill is a cleanup bill, because that is outdated language which remains in statute. So that does not currently exist under California law. The Reproductive Privacy Act is what determines what abortions are authorized in this state, and this bill does not change what abortions are authorized. Would you repeat your exact question for me?
Sure.
Thank you.
My concern is that the bill says you cannot use the cause of death as a reason for a criminal case, for bringing a criminal case or prosecution. So I'm just wondering how we keep people who are not supposed to be engaging in providing abortions, how then, where's the punishment for if they decide to do so? Because this says you can't use the cause of death. Let's say, person A is the one who performed the unauthorized or criminal abortion, whichever one you want to call it. Both are in the bill. So they do this, but the bill says you can't, and the inquiry has determined that, but the bill says you can't use that for a criminal case.
So the language in this bill protects people who are exercising their rights under the statute and those who help them. And so there are several points, if I can draw your attention to the section 123467. This language is pertinent only to a pregnant person in section A. Its intention is to make clear to actors like former District Attorney Fagundes in Kings County that California does not permit criminalization of pregnant people. Yesterday you mentioned the notwithstanding clause. That clause does not invalidate other laws that would apply to someone other than the pregnant person, such as someone who commits an offense against a pregnant person.
Okay, hold on. If I could stop you.
Sure.
Well, I just want to drill down on that particular bit, if that's okay.
Okay, well, I just want to be sure did you finish answering the question?
Okay, no, that's all right. If you want to continue your thought, go ahead. We'll come back to it.
So the term notwithstanding only applies to that subsection A, not B. A pertains to the pregnant person. So as I mentioned, if anybody, such as a prosecutor, seems to think that a law applies that would criminalize a pregnant person for their pregnancy outcome, this phrase makes it perfectly clear that the law does not. I'll also note that that section is limited to, quote, rights under this article, which are found in the statute, and that pertains to, quote, all matters relating to pregnancy, including prenatal care, childbirth, postpartum care, contraception, sterilization, abortion care, miscarriage management, and infertility care. So Section A is cabined and limited. Further, though I note it does not contain the term notwithstanding, which was brought up yesterday, Section B is also limited in several ways. So first, again, this section is limited to someone who aids or assists a pregnant person in exercising only their rights under this article. so limitation. And the section is further limited to based solely on their actions to aid or assist a pregnant person in exercising their rights under this article. And finally, this protection is all contingent on the pregnant person's voluntary consent. That is language in the statute as well. So any unconsented, negligent, or otherwise unlawful acts, like those that don't comply under 123.468, which is our what abortions are authorized, are still subject to other liability and laws.
Thank you.
Okay, but in section 123.467, where subsection A, where it says notwithstanding any other law, the person shall not be subject to civil or criminal liability. I'm not understanding why you say that that does not pertain to an abortion that is considered illegal or unauthorized. Because it says notwithstanding any other law, so that supersedes any other laws that we have on the books. So,
I believe
And that
you
only
addressed that
pertains
issue.
to the person who is pregnant.
right. So if it's the person who's pregnant, and she gets an illegal or criminal abortion, then this says she can't be held liable or criminally charged.
That is correct. And law in California is clear that ending or losing a pregnancy is not a crime. And in fact,
Well, it is if it's a viable fetus. It is a crime.
I'll refer you to the Attorney General's legal alert, which came out January of last year.
Right, but I don't think his legal alert said that you can't be charged with a crime if you get an abortion at any point in your pregnancy. I don't think that's what it said. Or did it?
So this bill does not change which abortions are authorized or unauthorized under California law. That part of the Reproductive Privacy Act remains as it is written.
Okay, but it says notwithstanding any other law. So even with section 187, which the AG addressed, and where he said this does not pertain to a woman getting an abortion, the intent, as I understand it, wasn't to indemnify an abortion at any point in the pregnancy. It was only for those abortions that are authorized. In other words, prior to viability or done by somebody who is legally allowed to do so. But this section says otherwise.
I respectfully disagree, Senator. So that section A is limited to rights under this article. You are correct. And so rights that are already provided for under the Reproductive Privacy Act would be covered by section A, but it does not expand the rights that are covered. And I think, did you want to?
Okay, well, we're going to have to agree to disagree.
Okay, yep.
Because I don't understand it that way, and the attorneys I've spoken with don't understand it that way, and the judges I've spoken with don't understand it that way, and I'm going to guess the opponents don't understand it that way either. But I would ask that if we're going to have the support witnesses comment on this, are we also going to allow the opposition witnesses to comment as well?
Well, did you have a question for them?
Sure.
Yeah.
Okay.
I mean, I just want to make
If
sure
I can
we're following the
clarify
rules.
too, there is no statute in current law that criminalizes a pregnant person.
No, that-
The statutes currently regarding what is authorized for, in terms of performing an abortion, relate to clinicians, and those laws all remain in effect.
Okay.
No, okay,
All right.
that's not what I was asking, but
Okay.
I will defer. I know she has some
All
questions,
right.
so.
Okay. Thank you. Senator Grove?
Thank you. Thank you. When I look at your bill and it talks about on section 7, line 29, it says on section 7, line 29, or you can go just a few lines up. Or you can start on 24. Notwithstanding any other law, a person shall not be subject to civil or criminal liability or penalty or otherwise deprived of the rights under the article based on the actions or omissions with respect to their pregnancy or actual potential or alleged pregnancy outcomes, including miscarriage, stillbirth, or abortion, or perinatal death due to causes occurred in utero. So that last sentence is what I want to ask you about. I was looking under definitions, and if you could point me to it, it would probably be faster. Can you tell me the definition of perinatal death?
Well, I'm glad you raised this last bit. We wanted to clarify the intent of the bill, right? Is that if something happens in utero, that and it causes a unfortunate circumstance where the fetus is lost essentially, or doesn't make it, this would ensure that the mother is not held criminally prosecuted for that act, right? And so an example of that, and we've seen this happen, there was a woman who was driving. She was about 8.5 months pregnant. She wasn't wearing her seatbelt, got in a horrific car accident. They had to induce, perform a C-section. The baby died, and she was criminally prosecuted for that. And so this bill will protect against those types of circumstances. And I'm happy to defer to our legal counsel if you want more specificity on the definition.
So the only thing I'm asking for is, I couldn't find, usually in these bills that we produce, it says definition of, labor, not labor as in labor and delivery, but any type of bill, there's definitions. And I couldn't find that section in your bill. So that's why I think it's very vague. And so I'm just trying to find out the definition. I mean, I understand what a stillbirth is. I understand what, let me go back to that code section. I understand miscarriage, stillbirth, or abortion. I understand that. But there is or perinatal death due to causes occurred in utero. So my question to you, because there's no definitions in your bill, it's so broad, you get several different definitions. Where's the definition of perinatal death in your bill? Or can you tell me what your intent is?
I think I just explained my intent, and yes. In utero, if something happens in utero.
Right.
Okay, so just to let you know where I'm coming from.
Add, by the way,
I'm not trying to argue. I'm really not. Yeah. Go ahead. I didn't mean.
I was going to say, and we actually worked pretty closely with the Catholic Conference on this, and worked closely with them, and they came off opposition because we clarified the intent of exactly what you're asking right now.
Okay. Yeah. I appreciate that. I think the Catholic Conference is wrong. We've replied to their withdraw. But they have the position on the bill. This is why I'm asking you this particular question. If you look at, do you know what the World Health Organization is?
Yes, I know what the World Health Organization is.
Well, I mean, I was just making sure. So the World Health Organization in perinatal death says that it's a baby between 22 weeks of gestation or weighing 500 grams or 7 days after birth. So I guess my concern with the bill is if this perinatal period is 7 days after birth and you have a botched abortion where you have a viable baby that's alive, where you said in previous responses to Ms. Melendez that your intent was not, that baby has rights. You said that. That was some of your comments. But if the World Health Organization is used by some slick attorney, the definition, that's a credible organization. Do you agree or not?
The World Health Organization? Yes.
Okay. So the World Health Organization says, again, 22 weeks of gestation, 500 grams, or 7 days after birth. So I guess my question is that if somebody was to take your bill and say, you know what, the World Health Organization says this is a perinatal death in utero. That's, what your bill says. How long, they would actually have up to 7 days to neglect the baby, let it lay there for 7 days, starve for 7 days, stabbed to death for 7 days, and under your bill, there'd be no investigation whatsoever.
Is that
true?
Not true.
Not true.
Yeah. Again, I'll repeat the same thing I've said a couple times now.
Okay.
If a baby is born and is alive, if there's any neglect, abuse, anything that results in that baby dying or being harmed, there should be an investigation.
Okay, so I get you're saying that. I do, and you've said the same thing to Ms. Melendez. Okay. But this is the problem. Just a little leeway, Mr. Chair. This is the problem. There's no definition in your bill to define what perinatal death is. The World Health Organization has its definition. Your intent, and I believe you when you say your intent is to make sure that infant death is investigated if the baby is born alive, okay? We all get that it's about abortion, miscarriages, not prosecuting women who lose their babies like you just described with the lady of the seatbelt. I understand what you're saying, but that's what we're trying to convey to you is that's not what the bill says. The bill does not give a definition, or I haven't found it. So if you could point to it.
In utero.
So,
is,
yeah.
is,
Okay.
what we're- is,
Yeah.
is clarifying the language
So,
to answer your
so
question.
can you, okay, can you give me, show me in what page or section your bill says the definition of perinatal
So,
death in utero?
so I think she answered the question, and so if you wanted to comment on her answer, that's fine. And I know that you're expressing your disagreement or your feeling that her answer is not meeting it, but I think she did answer the question that you asked.
Okay, so so since the chair is a doctor, and he understands that you answered the question, can you tell me where the definition is that says in utero, perinatal death in utero?
Well, that's what the bill says. The bill says perinatal death in utero.
But can you tell me where that's at?
That's, you just read it.
No, but
From
it's
the bill.
the definition. My question, Mr. Chair, was what's the definition
Oh.
of perinatal death in utero?
Well,
And you said she answered it, so I didn't catch it, but I'm not a doctor either.
Okay.
So I'm asking you as the chair, as a doctor, where is that at? Like, where's the definition perinatal death in utero?
Well, I think, well, let's put it this way.
Okay.
So we're not having a back and forth.
Yes.
And again, you can disagree, all right? I'm just saying that the word in utero means in the uterus.
Yeah, we know that.
So right, yeah. So that's what it says. So it says in the uterus. So once, if it's not in uterus, then it's not in utero anymore.
Correct.
So you can shove a code hanger?
Yeah, I guess. I don't know. Okay. Are you aware of a legal definition or a code section that references any definition other than what I found about the perinatal death for causes in utero? Do you, are you
We
aware?
clarified perinatal by adding in utero to make it clear that if something happens to the fetus while it's in utero, that results in the fetus dying, that the person cannot be criminally prosecuted for that. So in utero was added to clarify the intent around what we meant around perinatal.
Okay, so
Which we worked with, the Gynecologists Association, the midwives, and many others to clarify this in a way,
like precedents, like is
as
there
well as
something
Planned
out
Parenthood
there?
and others.
Can you point to anything that gives a definition of that statement?
All right, I think she's answered the question.
Is it just no?
multiple
Just it's
times.
no. There's nothing
In
else?
utero is the we're
Yeah.
adding clarity to perinatal by adding in utero. That is the clarity we
Okay.
sought to add.
Okay. Under this bill, there's also civil and criminal liability, which was discussed for any person aiding or assisting that person who self-performs an abortion and withholds care from the infant if it's born alive. That's how we see it, but that's not how you see it. So the answer is no.
Sorry, what is the question?
The question is, under the bill, I understand it to be that there's criminal or civil liability for a woman or any aiding or person assisting.
Like a medical provider?
Or your language says any person aiding or abetting. So I'm assuming it doesn't have to be a medical provider based on your bill, right?
So every medical
There's-
provider is licensed by an oversight agency in California that has to adhere to the scope of practice or the standard of care of the regulatory board. So there's oversight amongst all of our medical providers here, and that this law does not change any of that.
Okay. When you look at the $25,000 penalty in that section, I'm looking for it right now. It says any person that assists. So it doesn't say any medical person or any licensed person or any doctor or any abortion provider or any, it doesn't say that. It says any person who assists, right? That's what it says. I'm looking for it.
All right,
And Mr. Chair, if we could get
Yes.
clarity from legal
Sure.
counsel here.
okay, from the sponsor.
Hi there. I believe you're again referring to section 123.467B. Is that true?
B, this section should not be used to establish or bring support criminal prosecution civil action seeking damages against any
oh, it's line through person, any person who is immune from liability under this section. So it says any person, it doesn't say doctor or.
Yeah, so this section is limited in several ways, as I mentioned before. So
So can I, Mr. Chair, do I get to pick my witness to ask that question? I'd like to ask I'd like to ask the opposition attorney that question, if that's okay with you. Thank you. Could I have you come up?
Okay,
Sorry,
so
I don't know your name. I apologize. So this is my question, okay? And please don't go off on some, like we've heard before with like these long legal ramblings. It says that basically, this is what it's, I won't say basically, I'll say. So there's a $25,000 penalty for anybody who assists in prosecuting this person, this mother well, it says there's part of it that says in utero, the other part says it's not, but there's a difference of opinion there. This section shall be reused to establish or bring or support a criminal prosecution or civil case of action seeking damages against any person who is immune for liability under this section. What does that mean?
Okay, well, that's
From your perspective
her
as an
perspective.
attorney.
Yeah, okay, as the opposition.
Yes.
Please answer.
My name is Susan Swift Arnall, and I'm from the Right to Life League, and we had opposed this bill.
Yeah, actually, you can speak
Pardon me.
closer to the microphone.
Can you hear me now?
Yes.
Yes,
Thank
for the
you.
record.
I
Thank you.
apologize. For the record, my name is Susan Swift Arnall. I'm with the Right to Life League, and I'm a California attorney. We opposed this bill yesterday. What that means is it refers back up to, I believe it's section 123.467, which includes A and B of that section. Those two sections, 123.467, A and B, are the people, the persons who are immune from prosecution under the statute. And both of those sections, first, section A refers specifically to the pregnant person, the mother. Section B refers to anyone who aids or assists the pregnant person in obtaining her chosen pregnancy outcome. Therefore, the $25,000 suit that you're talking about in the section, I believe it's 9, applies when either of those entities, the pregnant person or anyone who assists her, is threatened with investigation, because a threat of investigation triggers the Civil Procedure Section 52.1. That's down in Section 9. So it's very clear that that is what triggers the liability for anyone, not medical providers. There's no definition of who these persons are. It is anyone who assists or aids the pregnant person.
Okay, that's the way I read it. The word is anyone. It doesn't, and just so you know, thank you for your response. The bill says anyone. It doesn't say anyone with a license, any doctor. I mean, that might be your intent, but that's not what the language says. And I think that's what Ms. Melendez was getting to yesterday. It might be that, you don't think that it covers outside of the birth of a child, but it does, because your bill doesn't say it, if that makes sense.
I appreciate the question.
Sure.
And I understand you're trying to get to clarity on it, and I want to help provide clarity. I'd love to have Ruth come up again and provide clarity on that point, because I think she was about to do that.
All right, Ruth, come up.
Sure. So, so that section is limited in several ways. First, it is limited to, you're correct, someone who aids or assists a pregnant person in exercising, quote, their rights under this article.
So can you just point me to where you're reading so I can follow along?
Sure.
Is that okay?
Again, that is section 123.467B.
Okay.
Okay.
Is protected.
Okay, sorry. Go ahead. I'm there now.
Sure.
Go ahead. I apologize.
So limited to in several ways. First, the section is limited to someone who aids or assists a pregnant person in exercising, quote, their rights under this article. It is further limited based solely on their actions to aid or assist a pregnant person in exercising their rights under this article. And third, this protection is all contingent on the pregnant person's voluntary consent. So as I mentioned before, anything that is against that person's consent or negligent or otherwise unlawful would still be subject to other liability. It is cabined in those three ways.
Thank you.
Okay, well, it still says notwithstanding. It still says anyone. So Okay, we'll disagree on that motion or agree to disagree. I guess, and I know this is like not going anywhere, but just for kicks. This would solve all of this. I mean, it really would. It would solve the whole thing, and I think it would really address a lot of things with the opposition. Again, I know you're trying to get it out of here today, and it's going to get out of here today, but if there was an amendment to amend Section 7 of the bill to add the phrase or something thereof, right? This section shall not apply to babies born alive as a result of an abortion, whatever, right? But the whole thing is that it appears, and based on where the bill started, that the intent is to the intent of the bill is to just make sure that, you know, individual babies that are born alive, it doesn't matter. It doesn't matter what happens to them within that definition of the World Health Organization and other definitions out there with the American Medical Association and all those definitions that have different time periods. And because you don't identify it in the bill, I really think that even though your intent is to not include that, there are lawyers out there that will take advantage of that in this bill. And my fear is that there will be a lot of individuals, whether it's a botched abortion, a baby born alive, the woman in the Tulare County jail that beat her stomach and the baby was born alive for, you know, I think that lived 7 minutes or something, but she was like 7.5 or 8 months pregnant. She beat her stomach so bad she induced an abortion. So just those things. I just think that without the bill drafted the way it is does not clarify all those things, which creates great confusion and great concern.
All right.
Thank you, Mr. Chair.
Thank you, Senator Grove. Are there other questions or comments from members? Senator Wiener.
Just very quickly, I think there are words that are so obvious in what they mean that you don't have to have a legal definition. You don't have to have a legal definition of the word bird. We know what the word bird means, or what the word table means, or what the word state capital means. We don't have legal definitions because that's what they mean. And the word in utero, or the phrase in utero, I don't have the slightest doubt about what that means. It's crystal clear, and I went and confirmed in the dictionary. It means there are two definitions of in utero. The adverb is in a woman's uterus. The adjective, I think it might be reversed, is happening before birth. So either happening before birth or in a woman's uterus. So I fully support this bill, and I thank the author for bringing it forward.
Okay, thank you. Any other questions or comments? Seeing none? Okay.
Okay.
Yes,
It'll be
comments.
brief. Thank you. Okay, so the problem, largely the problem with your bill is that word perinatal. I will tell you that, and I think you know that. And from what I understand, there's been a refusal to remove that word from the bill, which would probably solve all of these problems. But the bill does say that a person's not subject to these penalties or liabilities due to causes, perinatal death, due to causes that occurred in utero. So perinatal death could be the baby died while in utero. It could be the baby died after having been born. And it refers to, or it speaks to based on actions or omissions with respect to their pregnancy outcome. Okay, birth is a pregnancy outcome. That is according to the National Institute of Health, actually. They talk about pregnancy outcome is a vaginal birth, a cesarean birth, a baby that's born healthy, a baby that's born, with some birth defects or anomalies. It covers all of those things. So this bill seems to shield anyone who, or the mother, I guess, who, omits care from that infant once they are born. That's how I am reading this. That's how many other people are reading this, and I know that you disagree, but I stand by my comments that this is really opening the door to allowing people to operate in a space they are not authorized to operate in, and authorizing women to do harm to their babies and not not face the consequences of the law. And I get what you're trying to do, because I understand, I read the cases that you were talking about. I totally understand what you are trying to avoid. The problem is your bill has gone far beyond that, and I am just stymied by the fact that the one thing that could fix this is removing some of these words from the bill, and you haven't done so. So with that, I clearly will not be supporting the bill, and I just wish that you had more interest in fixing, working with the opposition and fixing the problems with the bill. Thank you, Mr. Chair.
Thank you. Any other questions or comments? So Senator Wicks, thank you for bringing this bill forward. I appreciate the work that you've done with the opposition. You got the Catholic Conference off, right? I think that shows that the work that was done. This bill, of course, has been heard in the Judiciary Committee, where it addressed many of the legal issues that we've also discussed today. Of course, we're here in the Health Committee, but I think it's important we don't criminalize people for being pregnant. And so with that, I'll be supporting the bill. Would you like to close?
Just appreciate, Mr. Chair, your work and your committee staff and the conversation here. Obviously, it's an important one. I've worked with opposition. We've clarified language. We've added in utero because of some of the questions that were raised, which did get some of the opposition off. But we may just have an ideological disagreement here with some of the folks on the dais. I'm committed to ensuring every birthing person in the state of California or people that come from other states have access to reproductive care. I'm committed to ensuring that people are not criminally prosecuted for any kind of pregnancy loss of any kind, and we have seen this happen in California. As mentioned yesterday, Adora Perez spent 4 years in prison, and that might not seem a lot like to some folks here, but that's a lot to me, and it's a lot to her and her life. So we want to make sure that we ensure that that never happens again. So with that, I respectfully ask for an aye vote.
Thank you. The motions do pass and be referred to the Committee on Appropriations. It's been moved by Senator Eggman. Secretary, please call the roll.
Han?
Aye.
Han, aye. Melendez?
No.
Melendez, no. Eggman? Eggman, aye. Gonzalez? Grove? Grove, no. Hurtado? Hurtado, not voting. Leyva? Limon? Aye. Limon, aye. Roth?
Aye.
Roth, aye. Rubio? Aye. Rubio, aye. Weiner? Weiner, aye. 6-2.
Okay. The vote is 6-2. Hold the roll open for absent members.
Thank you.